Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is, Are You on Board with Section 8? A New Era of Enforcement Against Interlocking Directorates. The ultimate responsibility for governing an incorporated business entity belongs to the board of directors. Here in the U.S., there's a federal antitrust statute that specifically prohibits interlocking directorates. That's where two competing corporations share at least one director in common. The statute we're talking about is Section 8 of the Clayton Act, and until recently, the antitrust agencies rarely enforced it, leaving it up to companies themselves to regulate their boards. But now things have changed, and we're going to hear about the renewed attention that Section 8 has been getting from the DOJ and FTC, and what companies need to know to avoid violations. My co-host today is Sergei Zaslavsky. Hi, Sergei.
Hi, Alicia.
Sergei, would you like to introduce our guest?
Sure. Well, we're very lucky to welcome Diane Hazel to the program. Diane Hazel is a partner in the Denver office of Foley and Lardner. She began her legal career as an attorney at the Federal Trade Commission's Healthcare Division. After that, following several years in private practice, she joined the Colorado Attorney General's office, where she eventually became the head of the Antitrust unit. Diane, welcome to the program.
Thank you. It's great to be here.
Well, let's start by setting the stage a little bit for our listeners on Section 8 and interlocking directorates. What does Section 8 actually prohibit?
It's probably better to just start out by defining what an interlocking directorate is. So, an interlocking directorate arises when a person serves as an officer or director of one corporation while simultaneously serving as an officer or director of a competing corporation. And the plain language of the statute says that no person shall at any time serve as an officer or director in any two corporations. And then it gives a sort of caveat other than banks, banking associations, and trust companies. And it provides that they must be in commerce and they must be competitors. So one thing to keep in mind about Section 8, it's a strict liability statute. Violations are illegal per se. There's no requirement to have to prove harm to competition. There are some thresholds that have to be met in order to be found in violation of the statute. Capital surplus and undivided profits. Right now, the threshold's around 45 million. The FTC updates that number every year in January, so be on the lookout for that. And then there are certain safe harbors that apply that really these safe harbors are trying to get to, maybe there might not be very much competition between the corporations when there's an interlock. And so the safe harbors are trying to say, because of that, we may not have as many concerns. Safe harbors, I will note, are fairly complicated. So if you think you may have an interlock issue, but a safe harbor might apply, that's always something to talk to counsel about.
What's the history behind Section 8? What were the concerns that really animated the passage of this law?
So we actually don't have a ton of legislative history to go off here, but there are a few things we do know. Congress, in passing Section 8, really sought to create this additional layer of protection to prevent the exchange of commercially sensitive information or coordination. So the concern is if an individual serves as a director or officer of two competitors, they'll be exposed to competitively sensitive information of both, and the information learned, may be shared with the other or could influence decision making. So Congress sought to stop incipient violations of the antitrust laws by essentially removing these opportunities that might be presented. I mentioned the safe harbors that exist. Those actually came about through some amendments in 1990. And with the amendments, there was a House report talking about Section 8. And it's interesting because the report talks about the Sherman Act and that it's there to combat the most flagrant anti-competitive practices, and then claiming that the Sherman Act maybe doesn't reach some other questionable restraints of trade, as the report says. And so one of those, quote, questionable restraints of trade are interlocking directorates. And the report goes on to talk about how these practices were really viewed as precursors to the growth of other practices outlawed by the Sherman Act. And so the report really kind of lays out what Congress was trying to do with Section 8 and with the updated amendments.
Now, in my introduction, I alluded to the fact that suddenly Section 8 has become a hot antitrust topic. And I can tell you, after practicing antitrust law for almost 30 years, I never once had a Section 8 issue come up. It just was sort of, I think I was aware of it, but I never heard of any real big time investigations, didn't have any clients involved in investigations. What has changed?
You're right, Alicia. It's definitely one of the topics du jour, but a couple things have happened with this administration. So we got a little preview, I think, that this was coming at the 2022 Spring Enforcers Summit. Assistant Attorney General Jonathan Cantor said that DOJ was ramping up efforts to identify and remedy Section 8 violations, and that it would not limit its Section 8 enforcement to merger reviews. So historically, these issues would come up, Section 8 issues, in the context of perhaps another agency investigation or merger investigation. And they may see something and bring it up to the companies, and the companies often typically resolved it by kind of getting rid of the quote offending interlock. So saying, okay, so-and-so will step down from the board. Following that announcement by AAG Cantor in spring of 2022, we then were hearing reports about letters starting to go out and maybe CIDs to public companies, private equity firms, individuals, investors, sort of trying to get information. Then that fall, the DOJ announced that 7 corporate directors were resigning from their interlocking board positions, and that essentially the remedy was unwinding the interlock. Then in March of this year, DOJ announced 5 more resignations, again with Section 8 concerns. And in that press release in March, the DOJ said that enforcement of Section 8 would continue to be a focus for the division. So we know it's still out there. And then more recently, in fact, this week, the FTC finalized a consent order involving an alleged interlock.
We know why this big change? I mean, the law's been in the books for over 100 years, as I understand, and not much has been happening until the last couple of years. So all of a sudden, there's a lot happening. Why the big change?
Various speculation why there might be a change. Again, we see different administrations focusing on different things, but we do know from statements by both the FTC and the DOJ that they believe there has been under enforcement in this area. So Chair Khan recently, in her statement involving this consent decree, gave some insight into the FTC's thinking on this issue and maybe what has prompted some of the changes. So she talks about the period of the 70s and 80s where Section 8 enforcement, was more commonplace, and there definitely were cases brought. And then, in 1990, resulted in those amendments to introduce the safe harbors. So Chair Khan was talking about that they feel there's been a decline in enforcement since those amendments, and that led to concerns of under deterrence. So really, according to Chair Khan, the FTC is just returning to its prior approach before the 90s. And the DOJ has echoed this sentiment, in a press release announcing these resignations. They said that they felt that Section 8 was an under-enforced statute. I do think if you also think and put this in the bigger context of other things we see going on, that Concerns about information sharing are also out there in various contexts. We saw both agencies this year withdraw the healthcare guidelines. 3 different sets of them, been around a long time. So we're seeing the agencies heighten concerns with information sharing, and they're choosing to use one of their tools to go after it.
How are the interlock cases coming to the agency's attention? There probably aren't that many major publicly traded companies that are running afoul of Section 8. They're all well counseled. So I assume a lot of these companies and organizations are, either middle-sized or small. And do the targets have a common profile?
So I mentioned before that there were reports that DOJ was sending out letters and in some instances, civil investigative demands. And that DOJ also said in one of these press releases that it was undertaking an extensive review of interlocking directorates. It's a little hard, if they have to know specifically what they may be doing, but it does seem there is some intent and target. Now, I also have to imagine that some are also just coming about still through the normal course of merger review investigations. The one EQT quantum consent decree that was announced that it had been finalized by the FTC, that came through an acquisition. So before, perhaps we might have just seen as part of any sort of consent settlement, or just that the parties would agree to get rid of the interlock. But now the agencies are being more proactive in saying, no, that is a violation of Section 8.
Now, one thing, and again, we don't want to get too deep into the technicalities of the statute, but my understanding was always that it only applied to corporations, that is, the entities that have, INC after them, and that it didn't apply to LLCs or other types of business or organizations. Is that something that the agencies, make a distinction between? Are they applying this statute to LLCs and other non-incorporated companies? What other ways maybe they be pushing the envelope?
So, Alicia, I think that's many of our understanding is that the statute applied to corporations, because that is the plain language of the statute itself. It says corporations. However, in this most recent consent decree we saw come out from the FTC, that involved a limited partnership. And Chair Khan issued a statement to a company when they first announced the preliminary consent, that the consent was putting industry actors on notice that they must follow Section 8 no matter what specific corporate form their business takes. And she specifically mentioned private equity, financial sectors, where there's often various limited liability vehicles or limited partnerships, and talks about how her view is in the FTC at this time is that Section 8's prohibition on interlocks among competitor corporations predates the development of these other types of structures. And she said that we must update our application of the law. So this is a fairly significant pronouncement, and I think puts everyone on notice that you can no longer assume that just because you are a non-corporate form that you possibly might not run into an issue with Section 8.
Kind of substantive issues usually come up in these cases. One thing you mentioned is that one of the requirements, the two companies have to be competing against each other. Is that something that is usually a source of disagreement, where the companies are actually competing against each other? As we all know, antitrust lawyers love to fight about market definition. Is this something that comes up in these cases as well?
So as far as substantive issues, what really is competition? I mentioned earlier the safe harbors. And so the safe harbors provide that you can look at what are really kind of the competitive sales between the competitors. And I know sales may not be a perfect metric for every company, but if they're low enough and kind of don't exceed a certain threshold, that really you're probably not going to maybe be at least in violation of Section 8. So that can be an issue that could come up. Another issue, Alicia mentioned and asked about, how maybe we're seeing the law pushed in some directions, is what we call indirect interlock. So just to kind of talk about terminology a little bit, when we're talking about a single individual simultaneously serving on two different competing corporations, I refer to that as a direct interlock. But now, what about if you have a single company or firm who is appointing two different individuals to serve on two competing boards? That I would refer to as an indirect interlock. So there is some debate of whether the statute actually reaches these indirect interlocks. Again, the plain language of the statute is using the term no person, and they're talking again about an officer or director, but it appears that the DOJ and FTC have taken a position that the meaning of a person for Section 8 means not only a natural person, but also potentially a legal entity. So under this interpretation, a legal entity could be in violation of Section 8 if it has representatives, albeit like different representatives, serving on the boards of two competing corporations or companies, as we've seen it being pushed. So I think this is definitely an expanded view of the statute and something to be aware of when thinking about these issues.
How do these cases usually play out? What kind of remedies do we see ultimately being imposed in Section 8 cases?
So traditionally, it's been unwind it, fix it, step down, fairly straightforward. Now it's that and then some. And so we saw in the more recent consent that there was a prior approval provision where one of the parties, it could not take a seat on the board of basically 7 other natural gas producers in a specific geographic area. They had to get prior approval before doing that. That consent also definitely said address both direct and indirect board service. Again, we're seeing that kind of expanded, what does person mean? Who does it apply to? Also saying, typical and consensus, a monitor is in place. So part of the monitor's job may be really kind of monitoring these interlock issues as well. So it's not just like step down anymore. There's more being put in place, and we'll have to see kind of how it plays out further and what other types of remedies may come about.
Sounds like there's not only stepped up enforcement, but also more remedies being imposed as well under the current administration.
Yes, I would definitely agree with that.
Expensive ones too. Monitoring is not cheap.
Exactly. Yeah, it's going to put more costs, and also just having a monitor, but also thinking about your own internal processes to monitor for these types of interlocks and what you might want to do to avoid getting tripped up.
So it sounds like it's definitely an important issue to keep an eye on because of the level of enforcement, because of the potential costs. What kind of practical advice would you give in-house counsel or outside counsel on how to help their clients make sure they still stay compliant with Section 8?
So at a minimum, avoid direct interlocks. And also, don't just assume because you're not a corporation that it won't apply to you. So the ways to do that may be you might want to, screen candidates before appointing folks to boards or officer seats to determine what other relationships they may have. Also thinking about periodic reviews, surveys. And some of this, I have to imagine a lot of companies already have this as part of, conflicts of interest on boards. And so some of that can be part of this process of doing your homework on that front. So, you can think about doing a survey, keeping a running list of who might be where to make sure that you're careful in this area. Also think about when you're negotiating deals, right? Is there a right to designate a board seat as part of the deal? Okay, well, let's think about that. Is there going to be an issue? Do you really need to do it that way, or is there a way to do it differently? Just making sure and being mindful. And then, of course, we can't forget that the agency's position right now is this expanded view of person, and that it can apply to the legal entity itself and not just the individual. So thinking about how that could play out as well if, perhaps you're some private equity or investment firm and you have portfolio companies, thinking through who's on what company do we maybe have an issue we need to be aware of. And it's all complicated, and I really would say to consult your counsel on these issues and work through ways to be compliant.
No, that's really the ultimate advice, because the safe harbors in particular are so important. There are these thresholds, and analyzing whether they've been met, whether you fall into one of the safe harbors or not, is not a do-it-yourself project. I will say that.
Definitely not.
Well, thank you, Diane. That's been a very interesting conversation. I know I learned a lot. I'm going to have to keep an eye out for interlocking directorates, maybe even add it to the syllabus of the little antitrust class I teach. But I suppose it will continue to be an issue, at least for the foreseeable future. Before we let you go, however, we're going to ask you the question that we ask all of our guests to try to get to know them a little bit better as people. And that is to tell us something interesting about yourself that is outside of your professional life.
So I do admit I'm a regular listener. I was a little worried this question might be coming as someone who doesn't think I'm particularly interesting. But I guess I would, talking a little bit about my career, and this is a little bit my professional life. I spent a year after my time at the FTC in Namibia. I had a Fulbright grant in competition law, and I worked with the Namibian Competition Commission, as well as some other government agencies, and had a wonderful experience working on capacity building and getting to know the competition issues they faced. And so it also just created this connection for myself with the continent. And I've served on a board that works with young women in Tanzania to help with mentoring and going to university, and also just travel there as much as I can. I've been to 11 African countries, and I'm always looking for opportunities to go back and help if I can.
That qualifies as interesting. Thank you. Before we go into the final segment, though, I actually wanted to let listeners know there are two papers that Diane and her colleagues have written about interlocking directorates and recent enforcement issues. Links to those papers will be posted on the webpage for this episode, along with a link to the ABA Antitrust Law Section's own publication. As it turns out, there's a Interlocking Directorates Handbook, which is a comprehensive book and guide to the law of interlocking directorates that the section itself puts together. So for people who want to know more, we have the resources that'll be on the webpage. Okay, heading into the home stretch, we're going to play a little game we call the Curious Hat.
And now it's time for the Curious Hat!
The rules of this game could not be any easier. Sergei is going to draw a surprise question out of a virtual hat. Sergei, would you please do the honors?
Sure. And the question for Diane is, what is your favorite hobby?
What is my favorite hobby? So I would say I lived in DC for a number of years. I moved to Colorado, and I'll be honest, one of the reasons I moved here is I love to ski. So skiing is my passion during the winter. Unfortunately, I have torn both my ACLs skiing, so this will be my return this winter after a ACL repair in April. But that is my favorite hobby.
Wow, the hobby has not been kind to you.
It has not.
Definitely pick the right city if you like to ski.
Well, it's been a pleasure. Thank you, Diane. Thank you, Sergei. And thank you to our listeners. Tune in to next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section, The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.